All right, so back on the record, state's attorney's present, defendant, defense counsel are present. There's been something brought to my attention by Deputy Millhouse this morning, and what's his, juror number, Mr. Cooper, number 15, works at LaSalle. And after court yesterday, went to work, and in his uniform, ended up on the elevator with Miss Samuel at LaSalle. He said nothing was said, but he obviously let Deputy Millhouse know. I also think that the other jurors heard that conversation and know that happened. Now, Miss Samuel's testimony, she said that she's been in custody. So I think, I'm not sure really what to think. So typically that would be a huge issue, but she did testify yesterday that she had been in custody.
She testified that she's been in jail for the last, I believe, 15 to 16 months, that she's been clean that whole time. And so the jury knows that part. So if the issue is, well, now they're aware that she's in custody, I think that any idea of that being prejudicial is kind of a moot point because they already knew that.
Mr. Vasquez?
Judge, I think because of the appearance of impropriety that I have to ask for a mistrial. I think on behalf of my client, I have to ask for a mistrial.
Let me do this before I rule on anything or make any decision. I'm gonna, let's just go off the record. I'm gonna do just a quick little research.
Go downstairs and ask them.
If everybody kind of take a look at any kind of case law that you can find with regard to that, and then is there anything else that we need to take care of with regard to the charge? Or anything before we bring the jury back in, Mr. Nichols?
No, Your Honor.
Mr. Vasquez?
No, Your Honor.
And no other requested additions or objections or corrections to that charge?
Nothing other than what we've already covered.
All right, same, Mr. Vasquez?
Same, no, just what we covered before, what I asked for.
Thank you. You can bring the jury in. Thank you. Good morning. Thank you guys for your patience this morning. We are back on the record. Jury seated. State's attorneys present, defendant, and defense counsel are present. At this time, ladies and gentlemen, I'm going to read the court's charge. I'm required to read it in full to you, and then you will have a copy to bring back with you into your deliberations. Cause number 23, DCCR 1793, the State of Texas versus Tracy Marie Samuel. Members of the jury. The defendant, Tracy Marie Samuel, is accused of murder. The defendant has pleaded not guilty, and you have heard all of the evidence. The parties will soon present final arguments. Before they do so, I must now give you the instructions you must follow in deciding whether or not the state has proved the defendant guilty. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable in this case. General principles. The indictment is not evidence of guilt. The indictment is a document required to bring the case before you. Do not consider the fact that the defendant has been arrested, confined, or indicted or otherwise charged. Do not draw any inference of guilt from any of these circumstances. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless the state proves each element of the offense beyond a reasonable doubt. The law does not require a defendant to prove her innocence or produce any evidence at all. The presumption of innocence alone is sufficient for you to return a verdict of not guilty. You may find the defendant guilty only after careful and impartial consideration of all of the evidence, and only if the state has proved the defendant's guilt beyond a reasonable doubt. The state has the burden to prove every element of the offense beyond a reasonable doubt. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If it does not, then you must find the defendant not guilty. If, after you have considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. To request that testimony be read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. That request must, 1, state that it is requesting that testimony be read back. 2, state that you have a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in dispute. The law requires that you render a verdict of either guilty or not guilty. The verdict of not guilty simply means that the state does not prove the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on the verdict. When you reach a verdict, the foreperson should notify the court. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. Your first task will be to select your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with the other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1. You must not discuss this case with any court officer or the attorneys or anyone not on the jury. 2. You must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the case until all of you are present again. 3. You must communicate with the judge only in writing, signed by the foreperson and given to the judge through the officer assigned to you. 4. You must not conduct any independent investigations, research, or experiments. 5. You must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Your sole duty at this point is to determine whether the state has proved the defendant guilty. You must restrict your deliberations to this matter. After you have arrived at your verdict, you are to use the form attached to these instructions. The foreperson should sign the line that corresponds to your verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Law specific to this case. The defendant stands charged by indictment of having committed the offense of murder. You will also be asked in further detail below to consider the lesser included offense of manslaughter. Relevant statutes. A person commits the offense of murder if the person intentionally or knowingly causes the death of an individual. A person commits the offense of manslaughter if the person recklessly causes the death of an individual. Definitions. A person acts intentionally or with intent with respect to the nature of her conduct or to a result of her conduct when it is her conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to a result of her conduct when she is aware that her conduct is reasonably certain to cause the result. A person recklessly causes the death of an individual if 1. There is a substantial and unjustifiable risk that her conduct will cause the death. 2. This risk is of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the person's standpoint. And 3. The person is aware of but consciously disregards that risk. Intoxication means a disturbance of mental or physical capacity resulting from the introduction of any substance in the body. Application of law to the facts. Although the state has charged the defendant with the offense of murder, you may find the defendant not guilty of that charged offense, but guilty of any lesser included offense. In this case, the offense of manslaughter is a lesser included offense of the charged and greater offense of murder. In order to find the defendant guilty of manslaughter, you must first find her not guilty of murder. To find the defendant guilty of murder, you must determine whether the state has proved, beyond a reasonable doubt, 2 elements. The elements are that 1, the defendant, Tracy Marie Samuel, in Jefferson County, Texas, on or about September 27, 2023, caused the death of Delbert Charles Lewis by shooting Delbert Charles Lewis with a handgun, and 2, the defendant did this either intentionally or knowingly. You must all agree on elements 1 and 2 listed above. If you all agree the state has proved, beyond a reasonable doubt, both of the elements listed above, you must find the defendant guilty of murder. and so indicate on the attached verdict form titled Verdict Guilty of Murder. If you all agree the state has failed to prove beyond a reasonable doubt one or both of elements 1 and 2 listed above, you must find the defendant not guilty of murder. You may then determine whether the state has proved beyond a reasonable doubt the lesser included offense of manslaughter. To find the defendant guilty of manslaughter, you must determine whether the state has proved beyond a reasonable doubt 2 elements. The elements are that: 1, the defendant, Tracy Marie Samuel, in Jefferson County, Texas, on or about September 27, 2023, caused the death of Delbert Charles Lewis by shooting Delbert Charles Lewis with a handgun, and 2, the defendant did this recklessly. You must all agree on elements 1 and 2 listed above. If you all agree the state has proved beyond a reasonable doubt both of the elements listed above, you must find the defendant guilty of manslaughter and so indicate on the attached verdict form titled Verdict Guilty of Manslaughter. If you all agree the state has failed to prove beyond a reasonable doubt one or both elements 1 and 2 listed above, you must find the defendant not guilty. If you believe from the evidence beyond a reasonable doubt that the defendant is guilty of either murder or manslaughter, but you have a reasonable doubt about which of these offenses she is guilty of, you must resolve that doubt in the defendant's favor. In that situation, you must find her guilty of the lesser offense of manslaughter. Of course, if you have a reasonable doubt about whether she is guilty of either offenses, you must acquit the defendant and find her not guilty. Voluntary intoxication. Voluntary intoxication is not a defense to the commission of a crime, but you are reminded that the state must prove all elements of the offense beyond a reasonable doubt. And then that is signed by myself. And then the last page is the verdict form. There are 3 options. You only choose one. The top is verdict not guilty. We, the jury, find the defendant, Tracy Marie Samuel, not guilty. And then there's a space for the signature and then the printed name of the foreperson. The second, verdict guilty of murder. We, the jury, find the defendant, Tracy Marie Samuel, guilty of murder as charged in the indictment. Again, a signature line, excuse me, and a line for the printed name of the foreperson. And then the last is verdict guilty of manslaughter. We, the jury, find the defendant, Tracy Marie Samuel, not guilty of murder as charged in the indictment, but guilty of the lesser offense of manslaughter. Again, signature line and line for the printed name of the foreperson. Mr. Nichols, the state has the option to start closing arguments. What would you like to do?
Your Honor, I'm going to reserve my time.
All right, thank you, Mr. Nichols. Mr. Vasquez, you may proceed.
Thank you, Your Honor.
Excuse me.
Mr. Nichols. Samuel.
Voluntary intoxication is not an excuse for any crime or anything in life. But the state of Texas still has to bring you evidence that this horrible event, this senseless death of Mr. Lewis, was caused intentionally and knowing. You have to bring that to you beyond a reasonable doubt. They brought you no evidence in the last 3 days. No evidence at all that this was done intentionally and knowing. I asked Detective Holmes on the stand yesterday, point blank, can you say this was done intentionally and knowing? He said, I can't say that. If I'm misremembering or misquoting, you can ask the judge to ask the court reporter to show you the transcript, that specific point. Detective Holmes, lead investigator in this case. All these things, all these exhibits, everything you've heard, the videos, all the reports were generated from him and his team that works with him. He knows this case better than anyone. And he said he couldn't say that it was done intentionally and knowing. What more evidence do you need than that to find Tracy not guilty. Tracy is a crack addict for the last 14 years and uses PCP as well. And you heard Detective Holmes say yesterday on the stand what PCP does. I can't remember his exact words, but it sounded like it was the worst of the worst. We don't know what that is. We don't know what it does to your mind or your memory. And you saw her testify yesterday. It's been 15 months since this event. And you saw her that night on the video. You saw her the next morning on the video. You saw her a week later on the video. She told Detective Holmes on the last interview, the October 3rd interview, 2023, in the interview room of the sheriff's office, that she told 911 that she accidentally shot Charlie. That's what she told him in the interview. She didn't tell them that. She didn't tell the 911 dispatcher that. She doesn't remember what she told anybody. We don't know what her world's like. She's not faking it. She's trying to find an answer to fit in the situation. Maybe she thinks she remembers some stuff. The only thing I can equate or analogize with it is a blackout drunk. And I mean a blackout drunk. You wake up the next morning, 8:30, your head's on fire. The last thing you remember is somebody or something you did, maybe 8:30 or 9 o'clock at night. You don't know how you got home. Your car's in the garage, so you assume everything went all right, but you have no memory of who you talked to after a while. You have no memory of your drive home. It got in there somehow, but you don't remember how. And if there's a dead body in your house, you're not going to know how that got there. It's a horrible, senseless death. But the state hasn't even come close to proving to you that she did this intentionally and knowing. There's a manslaughter instruction in the jury charge. I asked Detective Holmes if this was done recklessly. He said he couldn't say that. Please ask for the transcript for that specific one. There's no evidence of this is a murder. I suppose there's evidence that it was done recklessly, but it's not beyond a reasonable doubt. And I urge you to find Tracy not guilty.
Thank you, Mr. Vasquez. Mr. Nichols?
Thank you, Your Honor. Mr. Vasquez, ladies and gentlemen of the jury, I need 1 second. I want to pull up part of the video. He's right about one thing. She can't tell us what happened that night, because she has fried her brain over the last 12, 13, 14 years on PCP and cocaine, and was high when this happened, and has no recollection of what happened. So she can't tell you what happened. So all that is left is facts and evidence. We know the layout of that bedroom. We know bed's in the middle. Charlie Lewis sleeps on, if you're looking at the bed, Charlie Lewis sleeps on the left. His nightstand is next to him. Closet is next to it. She sleeps on the right side, and on the right side is that bathroom door. We know that she went in that bathroom and smoked crack cocaine shortly before she shot Charlie. She kept saying, I was watching TV. She said, no lights were on, just the TV. This isn't the exact best picture of it, but you can see the television. It's not on. TV's not on when the police get there. That's a fact. More importantly is, to get that gun, if this is the bed, she has to get from her side, intentionally and knowingly, walk over here and grab this gun off the nightstand and shoot the man as he sleeps right here. That's an intentional act, that is a knowing act. And when you do it high on cocaine, you better know bad things are going to happen. This is a senseless death. Charlie Lewis should be here today. He should be here with his family, his loving family. Why don't they have another 20, 30 years with him? Because of her actions. And yes, it does technically fit reckless, but it's more than that. It's more than just being reckless. Reckless is speeding down the street, racing somebody, and you crash and hit somebody else. Waving a gun around at 4 in the morning while you're high on cocaine is a knowing act. And for you to shoot somebody dead center in their chest is a knowing and intentional act. It would be callous of you not to feel bad for her. What's brought her to this point in life is tragedy after tragedy, but it's also choice after choice. Choice to not take advantage of first court-ordered rehabilitation and supervision programs. But she couldn't do that. She used while pregnant while on probation. And that was 10 years ago. And in the time since then, it's just ramped up to near constant cocaine use, near daily cocaine use, and PCP use. 3 weeks in October of 22 doesn't count as trying. 1 week in March of 2023 does not count as trying to get clean. And what did she tell you? The reason those programs failed was not her, it was other people. She won't take responsibility for the things she does. She won't take responsibility for the death she caused and blames it all on the drugs. Getting high doesn't excuse what you do while you're high, whether you remember it or not. And if you wake up in a blackout drunk and there's a dead body in your house, you better face the consequences. The 2 elements for murder. Defendant Tracy Marie Samuel in Jefferson County, Texas, on or about September 27, 2023, caused the death of Delbert Charles Lewis by shooting Delbert Charles Lewis with a handgun. That's 1. And there's no question about all of that. That much we know. And then 2, did this either intentionally or knowingly. It doesn't happen by accident. Guns don't just go off. Triggers have to be pulled. And when the trigger's pulled and it's pointed at somebody and kills them, That's an intentional and knowing act. You get in the weeds a little bit here. Intentionally or knowingly. The 12 of you have to agree it was done either intentionally or knowingly. Not all 12 of you have to agree it was done intentionally, or all 12 of you have to agree knowingly. The 12 of you have to pick either one gets you there. Manslaughter is a lesser offense. It is a second-degree offense punishable by 2 to 20 years. It's a cop-out. It's the easy way out for y'all, and I know that. And I'm asking y'all to focus on the murder, because that's what happened. In jury selection, I asked a question of several jurors. I said, why do we have to send people to prison? Why do we have to seek justice and punish people for what they've done? And the general answer was what? To hold them accountable for their actions. She's not taking any responsibility for what happened and hiding behind her drug use. I'm asking the 12 of you to hold her accountable for the death of Charlie Lewis and find her guilty of murder. Thank you.
Thank you, Mr. Nichols. All right, ladies and gentlemen, you've heard the evidence, the court's charge, and closing argument by counsel. I'm going to hand the jury charge to the bailiff, and he will bring you back to the jury deliberation room where you select your foreperson and begin your deliberations, and we will be in recess until you reach a verdict. You can go back with the bailiff now. All right, let the record reflect state's attorneys present, defendant, and defense counsel are present. And I have received a message that the jury's reached a verdict. And before I bring the jury in, ladies and gentlemen, obviously I know this is going to be emotional for everybody, no matter what it is. I ask that you please maintain courtroom decorum. If you don't think you're going to be able to handle that, I would ask you to please remove yourself from the courtroom. All right, you can bring the jury in. Bless you. All right, let the record reflect the jury is seated, state's attorneys present, defendant and defense counsel are present. At this time, I would ask the foreperson, has the jury reached a verdict?
We have.
And is it the unanimous decision of all the members of the jury?
It is.
If you'll please hand the form to the bailiff. Mr. Vasquez, Ms. Samuel, if you'll please rise for the verdict. Clause number 23, DCCR 1793. We, the jury, find the defendant, Tracy Marie Samuel, guilty of murder as charged in the indictment. You can have a seat now. Does either party wish to have the jury polled? Mr. Nichols?
No, Your Honor.
Mr. Vasquez?
No, Your Honor, it says they were unanimous.
All right, thank you. All right, so at this time, ladies and gentlemen of the jury, I receive and accept your verdict, finding the defendant guilty of the offense of murder as charged in the indictment. What that means is that the first phase of the trial is now over, and we'll move into the second phase, which is the punishment phase. Mr. Nichols, is the state ready to proceed with punishment?
We are, Your Honor.
Mr. Vasquez, or is the defense ready to proceed?
Yes, Your Honor.
What I'd like to do is go ahead and get started. If we have time for some brief testimony, then we'll take maybe just a little bit later lunch, get the charge ready and things like that, just like we did in the first phase. We have to do that as well. So, Mr. Nichols, would you like to make an opening statement?
I'll waive opening, Your Honor.
You may call your first witness.
They call to Marilyn Lewis.
Ms. Lewis? Good morning, ma'am. Do you swear or affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am. You can have a seat. You may proceed.
Thank you, Your Honor. Ms. Lewis, could you introduce yourself to the jury, please, and tell us why
My
you're
name
here?
is Marilyn Renee Lewis. I'm the ninth child of 10.
So you are a younger sister of
Yes.
Charlie.
Yes,
And Charlie was about in the middle of the 10 of y'all, right?
yes,
And he's the first one that passed away.
yes, he's the baby boy.
And, well, you understand that the jury has found Tracy Samuel guilty of his murder. And you understand what that means, right?
Yes.
Now's the part where I'm gonna get some information from you to help them understand how this has impacted you and your family, to help them make a decision, because what they're gonna end up deciding is between 5 and 99 years for life. Do you understand that?
Yes,
And so, Marilyn, what do you want this jury to know about Charlie?
Charlie was one of the best people, men, you would ever meet. Anytime you called on him, he dropped what he was doing. He was there. No matter what time of day or night, he was there. He'd give you, do anything for you. Anything.
Were you always dependable?
Always dependable.
From talking with different family members before and from what we've heard during trial, it seems like Charlie's a bit of a cowboy.
Cowboy.
And,
Yes, he used to ride bulls back in the day.
and
Which every time he got on one, I couldn't watch until he was off. Because where he rodeoed at, it was in like the clowns that were coming. It was your friends that to get out there and fight the bulls off. And I'm like, oh, Lord, this boy. But he did. That's what he did.
you're probably watching with your eyes covered at the same
Yes,
time. I
yes.
imagine. Your parents still alive?
Yes, my parents are. My mother she just turned 92. My mother just turned 91. My dad just turned 93. And when they called us, can I say that?
Yes, ma'am.
When they called us, it was late in the evening, between 6 and 7 in the evening. None of the family knew. None of us knew nothing about this that happened. The hospital finally got in touch with my parents. I worked at St. Elizabeth. I still work at St. Elizabeth for 42 years. And they wouldn't allow nobody, none of the family members, to come up there and be with him. They designated one person, and my parents said, because you work there, we're gonna designate you. I sat by his bed day and night. I took my clothes, work clothes, brought them to my department. When I couldn't no longer sleep in the recliner next to him, I would go down in my department. If y'all need me, call me. I'll be in my department. And I would lay in the bed in there. They allowed me to stay there as long as I needed to. every day, never went home, never did. We couldn't understand why, but the hospital had their rules. First of all, they didn't know who did this stuff. You know, if somebody was gonna come, you know, maybe one of the family members or whatever, and do some harm to him. So I sat there day and night. When I first arrived, the first day, they called it, they put him on sedation vacation. When they turned the sedation down, he was able to respond appropriate to everything I asked him. But what I did, everything we talked about, but what I should have been asking him, do you know who did this to you? Which he was trying to talk. He kept trying to talk, his blood pressure was shooting up, going up. Calm down, just calm down. I love you. Do you understand I love you? Yes. You love me too? He would shake his head, yes. Mom and Daddy is there. They couldn't come to the hospital. They up in their 90s, but they didn't have massive heart attack, open heart surgery, all this stuff. And it was hard on the whole family. They did not, I had to call the surgeon, the head lady over his department, the house supervisor, to try to get permission for them to allow some of my family members to come up there. And finally, they did. The day before this man passed away, when they knew he was gonna die, he couldn't make it, they let family members come in, one at a time, or two at a time. But it was hard on the whole family, still hard. Parents couldn't be here in court. They watching. My dad, blood pressure went up. Just the other day, he couldn't hardly stand it. Their baby boy is gone. Charlie loved to do what my dad did. My daddy was a cowboy, rodeo. They spent a lot of quality time together, always together, always. And it's just so hard. It's just so hard for the whole family. Even the little babies, the little bitty ones, every time they see him, Uncle Buck, they would call him Uncle Buck. Uncle Charlie here, Uncle Charlie here. And she stole that from us. She stole it from us. And that's a hurting thing. We'll never get him back. Never. Never. I can't call him and say, Charlie, I need you. I love you. Nothing. It's just, it's devastating. It's devastating.
How many nieces and nephews do you have?
Let's see. My mother and them have 30-something grandkids. 80-something great-grandkids. I don't know how many great-greats. They live to see 4 generations. And their baby boy's gone. Over something that this girl did, our family. She destroyed our family. Took our brother away from us. Took my mom and daddy, baby boy, away from them. We're all gonna leave here one day. We knew it from the day we born. But he didn't have to go this way. She chose to do this to him.
Miss Lewis, I know nothing can bring your brother back, fill that hole. But at the end of this, there's gonna be a sentence, some term of years or life on Tracy Samuel for what she did to your brother. What do you want to see happen?
She needs to get the maximum. The max. Because she took her brother away from us. Our loved one is gone. Not hers. Our loved one is gone. She needs to get the max.
Thank you, ma'am, and I'm so sorry I'll have to be here. That's what.
Mr. Vasquez, any questions of this witness?
No,
Thank you, ma'am. You can step down. Any other?
It's time to stay rest. It's case closed.
Thank you, Mr. Nichols. Mr. Vasquez, do you wish to call any witnesses?
Yes, Your Honor, call Kathy Veal.
Okay, Ms. Veal? And Ms. Veal, if you'll just raise your right hand, please, ma'am. Do you swear or affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can have a seat. You may proceed.
Thank you. Ms. Veal, state your name for the record, please. Your name for the record.
Kathy Veal.
I know you've been here for the whole trial, watched everything. I know you're disappointed. You were hoping there'd be something lesser, a lesser included. My questions are kind of like Mr. Nichols, except I'd like for you to tell the jury what you'd like for them to know about Tracy.
Well, first of all, I want to say to the court, Tracy's a good girl. She had a drug problem, but she definitely was a good child. She had a good one. She was always trying to help some other person. And from the very beginning, when she was a little bitty girl, she loved people. And some of that part that kind of got her, she didn't know what people to help. She always would help the wrong people that would stab her back in her back. But she was always a good child. Never gave me any problem until she got on the drugs. And when she got on the drugs, they began to take her further away from the family and reality. But she would never, ever, ever, ever hurt anybody. Whatever happened that night, it was an accident.
Well, let's not go into that.
Okay.
If this jury's found her guilty of murder,
Okay.
when did these drug problems start?
I believe when she probably was 18, 19, something in that way.
So 20-something years ago. And what was, if you can remember, what was that like, and who was trying to help her not go that route?
Well, most of it, she realized that she had a drug problem. She would go to different rehabs trying to get help. She was crying out for help. She always cried out for help. And she went to about 4 or 5 different rehabs, but they never kept her longer than 2 weeks or a week. So with that being said, her being on drugs that long, 2 or 3 weeks didn't help her in that order. But she did try to cry for it. And she wasn't ordered to go to rehab. She went because she knew she needed it.
But she didn't stay long, and
But they didn't keep her long. They did rehab last about 3 weeks at the most.
was this all in Beaumont?
I know it's different in Houston, Dallas.
That's
and
right. That's right. There was a facility in Houston, facility in Dallas, and where else?
Can't remember the last place she went, but it was out of town as well.
Was she living with you part of this time?
Yes. Well, not when she was grown. She was 18, yes, but she lived with Mr. Charlie. I call him Mr. Charlie because he's an older guy than my daughter.
Tracy's a 40-year-old woman now.
She is.
Is there anything you want to tell the jury other than what you've already told?
I want to tell y'all that she's a good girl. I made the decision that she was guilty. She was guilty of some things. She was guilty of being on drugs, not knowing how to get the help. She went for help, but not understanding how to stay off of drugs, not getting a sponsor when she should have got a sponsor. But she would give you the shirt off her back. She was that kind of girl. She's my baby girl. And she's a lovely person if you got to know her. You really would. You would love her. She was funny. She'd make you laugh.
But she wasn't living in reality.
Sir?
She wasn't living in reality a lot of the last part of her life.
But
to get to know us so well you will love her.
Thank you, Ms. Field. That's what you show.
Any questions, Mr. Nichols?
No, Your Honor.
Thank you, ma'am. You can step down. Mr. Vasquez? Any other witnesses, sir?
We rest, Your Honor. Sorry, defense rest.
All right. So what that means, ladies and gentlemen, is that's the new testimony and evidence that you will receive. What I'm going to do now is we'll take a break, but I'm going to have you guys all go back into the jury room and we'll figure out lunch and some things like that. And then we will get started again at 1:15. There's a meeting that has to take place here in this courtroom, so we're going to go just a little bit longer, work on that charge, get it done, and we'll start back at 1:15. So if everyone would just remain seated for now, ask the jury, y'all can go back into the jury room, please. Before we take our break, Mr. Vasquez and Mr. Nichols, Ms. Melfino, I've emailed y'all court's proposed charge on punishment. I did several varieties. There was one prepared that was for this, in case of this. If you'll take a look at it real quick, it's very simple, shouldn't have any issues, but make sure that I made the appropriate changes that I needed to. And we'll take a break and get started again at 1:15. All right, state's attorney's present again, defendant and defense counsel are present. Anything else before I bring the jury in?
Not by the state.
Nothing from the defense.
Okay. Make sure. All right, you can bring the jury in. How long would either of you request for closing after we read the charge?
I don't anticipate being more than 10 or 12 minutes.
Okay.
The same, in that.
All right, thanks for y'all's patience downstairs. Apparently there was a lot of people, sent the jury down for lunch and it took an hour for them to get their food. So I'm sorry for the delay for everyone and for you guys. At this time, let the record reflect jury seated, state's attorneys present, defendant and defense counsel are present. Again, you've heard all the evidence with regard to punishment. I'm now going to read the court's charge to you and then you'll hear closing argument by counsel. Cause number 23, DCCR 1793. State of Texas versus Tracy Marie Samuel, jury instructions. Members of the jury, you have found the defendant, Tracy Marie Samuel, guilty of the offense of murder. Now you must determine the punishment to be imposed on the defendant. The parties will soon present final arguments on punishment. Before they do so, I must now give you the instructions you must follow in determining the defendant's punishment. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable to this case. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. In determining the sentence to be imposed on the defendant, you may take into consideration all the evidence admitted before you. This includes the evidence admitted during the first stage of the trial concerning the defendant's guilt, as well as any evidence admitted during this punishment stage. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. To request that testimony be read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. That request must 1. State that it is requesting that testimony be read back. 2. State that you have a disagreement about a specific statement of a witness or a particular point in dispute. And 3. Identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that's in dispute. You must arrive at the amount of punishment by a full, fair, and free expression of the opinion of the individual jurors. You must not decide the punishment by lot or by chance. For example, you may not agree beforehand to be bound by the result of a procedure by which each juror gives the number of years the jurors thinks should be served. These are then added and the result is divided by 12. To reach a verdict, all 12 of you must agree. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. The forepersons should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1. You must not discuss this case with any court officer or the attorneys or anyone not on the jury. 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, you must stop your discussions about the case until all of you are present again. 3, you must communicate with the judge only in writing, signed by the foreperson and given to the judge through the officer assigned to you. 4, you must not conduct any independent investigations, research, or experiments. And 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your foreperson sign his or her name to the particular form that conforms to your verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Specific law applicable to this case. You have found the defendant, Tracy Marie Samuel, guilty of murder. This offense is punishable by 1, a term of imprisonment for no less than 5 years and no more than 99 years or for life, or 2, a term of imprisonment for no less than 5 years and no more than 99 years or for life, and a fine of no more than $10,000. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, she will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if she's sentenced to a term of imprisonment, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. And then that's signed by me, and then you have the verdict sheet. There are 4 options. You will pick one. It reads, we, the jury, having found the defendant, Tracy Marie Samuel, guilty of the offense of murder, assess her punishment at. And then the first is imprisonment in the Texas Department of Criminal Justice for a term of blank, 5 to 99 years and no fine. The second, imprisonment in the Texas Department of Criminal Justice for a term of blank, 5 to 99 years and a fine of blank, $10,000 or less. The third, imprisonment in the Texas Department of Criminal Justice for life and no fine. And then the last, imprisonment in the Texas Department of Criminal Justice for life and a fine of blank, $10,000 or less. And then that has the line for the signature and the printed name of the foreperson. Mr. Nichols, the state has the right to open and close argument.
And I'll reserve my time.
All right, thank you, Mr. Nichols. Mr. Vasquez, you may proceed.
Thank you.
Mr. Nichols, Ms. Martino, Ms. Samuel. This is always hard to start because you've already rejected my request earlier, my argument earlier. Don't agree with your decision, don't like it, but respect it. I respect the fact that y'all listen to all this and look back and deliberate. I suppose I'm just gonna echo a lot of things that Miss Tracy's mom, Miss Deal, said. Terrible act. I don't think she's a violent person. She, probably the last 15 months have been the first time she's been drug-free in 15 years. It's awful that it had to come to this and the loss of Mr. Lewis's life. I'm asking you to consider the fact she's a 41-year-old woman, and you have a chance to give her a sentence where she can get out and still have a life. Has children that she hasn't done mother to. But if you show her mercy, she goes away, continues with whatever rehab programs, whatever she can continue to do to in her sobriety, she can get out. I'm just asking you not to throw her away and to give her a chance. I swear I'm not one of those bleeding heart types. I'm not at all. But I've heard someone a lot wiser than me say, you judge a society on the mercy it shows it's weak, it's sick, it's disenfranchised. And I'm just asking you to consider all that and show mercy in your love. Thank you.
Thank you, Mr. Vasquez. Mr. Nichols?
Thank you, Your Honor. May it please the court. That's good. Yes, sir. Thank you. You're not throwing her away by dispensing justice in this case. It is a horrible thing that we're here for. And I've heard from two families that are going to be, they're altered forever. She still has her life ahead of her. Charlie Lewis does not. The Lewis family has a hole in its unit now that she caused. And all the tears from both families and all the horrible things y'all had to sit through and hear about this week, it's not for anything I did, or the police did, but for what Tracy Samuel did to Charlie Lewis. I'm not asking you to check all compassion and mercy at the door. It would be inhuman of me to pretend we don't feel bad for the things that led to Tracy being here convicted of murder. But I am asking you to hold her responsible for the things she did. You have a wide range of years or life available to you. You've heard from Charlie's sister that the family, they want as much justice as they can get for their dead brother. And I can argue with that. And maybe you would have some compassion, like Mr. Vasquez asked for Tracy Samuel. And I'm going to say something that sounds pretty harsh, but so is murder. An undeserved mercy for the guilty is a further injustice for the victims. It is harsh, but it is true. The Lewis family deserves justice for what they've been through. Charlie deserves justice. And Tracy Samuel deserves justice. And it's not always easy or pretty. And it doesn't bring anybody back. But taking another's life because of this sickness, this addiction, but this choice to keep using cocaine and pick up a gun, it deserves a harsh sentence. I know it's not fun and it's not easy, but that is what we're asking you to do. Thank you.
Thank you, Mr. Nichols. All right, ladies and gentlemen, at this time you have all of the evidence, the charge, and argument by counsel. I'm going to give the bailiff the charge. Again, he'll take it into the jury deliberation room and get you guys settled, and we will be in a recess until you reach your verdict. If everyone else please remain seated, you can go back with the bailiff. Mr. Vasquez, before we break, I'm going to hand you the certification. If you and Ms. Samuel will go ahead and get that signed so it's prepared at the correct time.
Yes, ma'am.
And just put it back up here and I'll take care of it. And court will be in recess until they've reached a verdict. All right, let the record reflect state's attorneys present, defendant and defense counsel are present. I've received a message that there is a verdict on punishment. Ladies and gentlemen, you all have been very gracious and cooperative. Again, I ask you just the same thing with this verdict, whatever it is, to please keep your emotions in check the best you can. All right, if you could please get the jury. All right, let the record reflect the jury seated, state's attorneys present, defendant, defense counsel are present. I would ask the foreperson, has the jury reached a verdict?
Yes, ma'am.
And is it the unanimous decision of all of the members of the jury?
It is.
Thank you, sir. You can hand it to the bailiff. Mr. Vasquez, Ms. Samuel. We, the jury, having found the defendant, Tracy Marie Samuel, guilty of the offense of murder, assess her punishment at institution imprisonment in the Texas Department of Criminal Justice for a term of 30 years and no fine. Mr. Vasquez, do you wish to have the jury polled?
No, Your Honor, they said, you know.
Mr. Nichols?
No, Your Honor.
All right, at this time, then, y'all can be seated. At this time, ladies and gentlemen, that means the trial is over. I handle things, you'll stay seated. I'm going to go through a few things, and then I'll come down and visit with you for a little bit after we clear the courtroom out, and then I'll dismiss you and give you your instructions. And is there any reason not to go forward with sentencing at this time, Mr. Nichols?
No, Your Honor.
Mr. Vasquez?
No, Your Honor.
Then, Ms. Samuel, at this time, in conformity with the jury's verdict, I sentence you to a term of 30 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You're going to be handed the trial court certification. This shows that this is not an agreement. You do have some rights to appeal. You can talk to Mr. Vasquez about that. You're also going to be handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. I'm required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can also talk to Mr. Vasquez. You will be remanded to the Jefferson County Sheriff's Department until your transportation to the Texas Department of Criminal Justice. You can go back with the bailiff at this time. Thank you, Mr. Vasquez. Thank you, Ms. Molfino, Mr. Nichols. Thank you all for being here. These are difficult cases for everyone. I appreciate everyone that was here, how you all conducted yourself. I'm so sorry for your loss, and for you all as well. I'm sorry that this is just a terrible situation for everyone. Court is now adjourned.